Hi everyone, welcome to the third installment of Tech Tuesdays. I'm Christy Bagalow, the Director of Statewide Training at Florida Legal Services. And today we are very fortunate to have with us two experts in the domestic violence field. We have Marta Estevez, she's the Deputy Director and Senior Attorney in the Family Law and Domestic Violence Unit at Coast to Coast Legal Aid in Broward. And we also have Jessica Abel, who is a staff attorney at Three Rivers Legal Services in their Lake City office. This webinar is being recorded. Zoom does not automatically send out the recording on the Zoom meetings, but I will be posting this to our new FLS YouTube page, which I just launched this week. So I'll put that in the chat box for everyone to check out. There is CLE credit pending, I promise. It didn't quite make it in time. We've still got another hour, so maybe it will come through during the webinar. So if it does, I'll announce it. If not, I'll put it with the video on YouTube. After this Tech Tuesday today, we'll be taking a small break until September 22nd. That'll be the next Tech Tuesday. So I'll also put the flyer for that one in the chat. And after this webinar, we'll have optional breakout rooms if anyone wants to network, socialize, share ideas about what you've heard during the webinar today. So that'll be at the end of the webinar, and it is optional. So thank you so much, Marta and Jessica, for taking time out of your super busy schedules. Domestic violence work is really hard during the best of times, and we are not exactly in the best of times right now. So I really appreciate you two sharing your expertise with us. Welcome.
Welcome, everyone. First, I'd like to thank Christy and everyone who's participating today for allowing Jessica and I to present on some tech topics for domestic violence injunction hearings and Zoom hearings in general. Like Christy said, my name is Marta Estevez, and I am practicing and have been practicing in Broward County, Florida now for 15 years with Coast to Coast Legal Aid. I primarily handle domestic violence injunction hearings for survivors of intimate partner. Our county has been operating via Zoom pretty much since the courthouse closed on the 17th of March. Our circuit is pretty big at the 17th Judicial Circuit. We have two full-time DV divisions. They run DV docket day in and day out, as well as 15 members of the family bench who under Unified Family Court handle domestic violence hearings pretty much on a daily basis. So our numbers are pretty big here in Broward County. I will tell you that since we have been in shutdown, we've had a couple of tweaks to the system, but I think we're finally coming to a point where we are getting more comfortable with the use of technology. Although, as Jessica and I will get into, we do see that there are some pitfalls, specifically for domestic violence survivors and for those people who are at or below federal poverty. As we delve into our discussion today, I'm going to try and point out some of the things that we feel are economic inequities which would impact a participant's ability to meaningfully participate in their hearings, and that could have things to do with their Wi-Fi access, their actual devices that they have available to them, the locations where they're at. So I'm going to start sharing my screen, and in the meantime, Jessica is going to do a quick introduction of herself as well.
Hi all. So so like she said, thank you guys so much for being here and for listening to the talk today, and hopefully something's useful in it. Just so you guys know where I'm coming from, as said in the introduction, I'm out of Three Rivers Legal Services, Legal Aid, which is I'm in the Lake City office, which covers the 3rd Circuit, which is 7 counties. It's 7 very rural counties. I would list them, but it's probably not going to help you if you don't know where they are. You're still not going to know when you hear them. They're all small, though. Lake City is the biggest town of all 7 counties, and it's still tiny. So my input's going to be kind of more from dealing with it in a rural environment, and that has some unique challenges and some unique advantages. So we're going to kind of go back and forth about things and go over that. I'm going to kick it back to Marta now to go through her thing.
So as Christy was saying, we're going to open this up for discussion later. There will be breakout rooms. I'm going to stick around. I'm sure Jessica will too if anyone cares to join in the breakout rooms and ask us questions. But the chat is also going to be monitored. And so if you have a question or something that you want to ask us, feel free to put it in the chat. Christy's going to be looking at it and kind of updating us regularly if there is a question. So the first thing we want to do is set some expectations. What is it that you're going to learn today in the Tech Tuesday? What are the topics that Jessica and I are going to discuss, and what do we plan to get out of it? So first, we're going to talk about just Wi-Fi access in general for these injunction hearings. We're going to talk about some of the safety and privacy concerns that we've been seeing and some of the considerations we should take as practitioners in domestic violence. We're going to talk briefly about the presentation of evidence and how we can assist pro se litigants in presenting evidence and how we as practitioners can present it. And then finally, we're going to talk about wardrobe malfunctions, and just some general don'ts when it comes to Zoom hearings and our appearance in our courtroom settings. All right. So technical inequities are the first things that we're going to talk about. And we're going to talk about how we as legal service providers see technical inequities as an issue or a barrier to representing those that are at or below federal poverty. I myself here in Broward County will tell you that some of the things I see are the use of phone versus computer. And what I mean by that is that not all of our participants or clients have access to a computer. Most of us carry around a smartphone, and that has pretty much substituted and replaced our computers at home. So the use of a phone is much different for participation in Zoom hearings than the use of a computer. And so we're really seeing how that has an impact on the way a survivor participates in their injunction hearings. Also, the camera qualities and the sound qualities often tend to be better if you're at home in a quiet environment using your home Wi-Fi with a laptop than it is on a cellular device. Jessica, do you have anything?
Yeah, just to add, and one of the things kind of when people are using their phone that I've realized I've had to start saying to people, make sure, is remind them of the difference between Wi-Fi versus their data access. Because if they're on a data plan, the video calls will eat into that data real fast. So I've realized, because I learned the hard way during a hearing when a person was like, I got to get off this hearing quick because my data's running out. To really have that conversation up front, that could be an issue that needs to be addressed. Like, hey, if it's going to be on, you probably should be on Wi-Fi because it's going to eat into your data. And I think that's, something to note if they have to use their phone. I do think the computer is ideal, but goodness knows we're not in ideal times.
And it perfectly segues us into payment and continuous service for Wi-Fi and wireless service. So it's been my experience that sometimes a client is really hard to get during certain periods of the month. And that's usually the period of the month when they haven't been able to make their cell phone payment or their cable payment, and both their access to their cell or to their home Wi-Fi has been stopped by the cell phone provider or the wireless carrier. In addition, I also have seen that there's been retaliatory shutoff by an abusive spouse who knows that the petitioner has no other access but his or her cell phone and or their Wi-Fi at home. So they cut off the cable, therefore cutting off their access to Wi-Fi, and they cut off their cell phones. So those are two things that we see, and it's been a struggle for the most part to educate judges that sometimes a petitioner's failure to appear is not willful. It's just a lack of access to the devices that the court is now imposing that petitioners have available to them. And so I've been really trying to struggle to ask the court to grant brief continuances to allow me to make contact as an officer of the court with the client via some other method and see why he or she is not participating in that scheduled hearing.
Yeah, and I think I've definitely done that prior to hearings, be like, I've talked to them, they were supposed to be on, can you give me 5 minutes to make a phone call? Yeah, I mean, I think that's a big point, and which I think Marta's about to get to this point, but I'll segue a little bit into it, and also about other options if they don't have phone or internet options at home. I've had people come into the office, or I've met with them at our office to do it, especially for hearings that are contested and expected to be long. That may not always be an option depending on health concerns and the nature of your business and your office and transportation concerns. So we've also reached out to some community partners to try to find other options to make sure people have those options. Like some of our domestic violence shelters have let people come into their offices and have volunteered the use of their conference room to use their office and their computers and their Wi-Fi, so that they have a safe and secure place to do that. So I definitely think reaching out to any community partners or other options, as much as possible, And also following up on those options when they do exist to make sure they are safe and secure. Because one of our courthouses decided they were going to offer people to come to the courthouse and do it from the courthouse via their cameras, kind of like in the first little vestibule area where you walk in, which seemed like a good option until we realized afterwards that they were going to have the victim and the alleged batterer about a foot apart if they were both there standing next to each other doing theirs. So that was clearly not a good option at that point. So definitely, even if things sound like a good option, make sure the details really work out that way. So there's lots of different ways, but definitely trying to get them somewhere that's safe and secure, be it your office, be it their home, be it other community partners, kind of depending on what their environment and their options are.
And that is also very important for us, not to make assumptions that our clients have access to devices that are capable of Wi-Fi connectivity. So although there are Wi-Fi spots available and you can probably sit out by a Dunkin' Donuts or a Starbucks and kind of surf their Wi-Fi, it's not always the most reliable. You're going on a public network to do so. You may lose connection, some of them time you out, and so therefore you might get kicked off either while you're waiting for your Zoom hearing to be called, or you also might just get kicked off in the midst of your testimony. And so, we're struggling to have our clients participate, but also to understand and come at it from a point of understanding that there are barriers to them having access to some of these devices and some of the equipment that we're asking them to have. The Wi-Fi hotspots brings us to our next issue, which would be confidentiality. And what happens when a participant, a petitioner specifically in a restraining order or injunction hearing, is discussing these things at a local hotspot? And it takes us to a new place where we're now asking a victim to possibly tell his or her story in an open forum where other people might be hearing the allegations or the incident that occurred. And especially if it's an incident of some sort of sensitive nature where there have been allegations of sexual abuse or misconduct by the other party, we're now asking someone who possibly is either at a cafe outside somewhere or in their car to be expressing themselves about something very personal and private in an open forum, and it's subject to other people listening. And although our courtrooms are open, when we're in a traditional courtroom, that has some control and some means of controlling who is listening to it by the staff. And that's not something that we really have when folks are either sharing a house with a roommate or a friend or living with friends, maybe even at shelter with other shelter participants. So confidentiality really becomes an issue in what we're exposing our clients to do or say out in an open forum.
Those are such good points. I'm really glad to hear that community partners are stepping in to help. We did already have one question come in along those lines, so I just wanted to check and see if you all had any more to say about this. But Lauren asked, do you believe as practitioners it's our responsibility to take steps to have clients in office with us, even with the health risks, if they only have a cell phone or if they don't have a cell phone?
I think if you want a participant, depending on the complexity of what you're going to be presenting, I would say start there. If you believe that access or limited access to technology is going to impact your case negatively, then yes, I would say take precautions either at your own place of business or, as Jessica pointed out, work with community partners. At Coast to Coast, we're really fortunate to have a strong relationship with our victim advocates from our local police-based offices. And so I have had them ask and say that they could set something up for our petitioners to go there. We know it's a safe place. It's inside the police department. Our shelter has also offered to give that space and that privacy to some participants. So it's all a matter of, do you think that their limited access to technology is going to negatively impact or influence their participation in a hearing?
Yeah, I think that really is the main thing. At the end of the day, if it's a non-contested hearing that everyone's going to agree to, that's fine. You don't need to all be there in person and be in the same room as them. If it's an all-day trial that's going to be contested and lots of evidence, that's a different story. You're going to need to have, not necessarily be in the same room for them, but either be in the same room or have creative options available, be that reach out to partners or anything else and have a way to communicate with your client via email, via text during the hearing if you're not in the same room as them and you don't want to communicate on the record. And the judge won't let you have a breakout room or anything, which some judges will, some judges won't. So yeah, so I would just be very mindful, I guess, of what the impacts would be with the different options, if it can be done separately, if not, and just kind of really, this is the chance to be very creative in your options and flexibility and try different ideas. And sometimes it's a good thing, sometimes not so much, but that's where we're at right now, I think, for a lot of different things.
On the topic of confidentiality and privacy, one of the things that we need to look at and factor is now, at least in our county, children are participating in virtual school. And so that adds another layer of complexity to this, because you're asking petitioners if they have minor children in their care and custody at the moment, and they're going to be participating in these Zoom hearings, that potentially little ears can be picking up some very adult conversations that they don't necessarily need to be involved in. And so that's one of the things that I always counsel my clients to, as, who is going to be around, who's going to have access to come in or out of the room or the area that you've set aside to testify in, and really making sure that they understand the possibilities that other people can hear and how to best safeguard from that information getting out to either roommates, family members, or even the children that are in the home. Talking about safety concerns in Zoom, one of the things that I noticed is that some of our clients, like I said, either because of a shut off of their phone system, because they've relocated, because they've tried to switch information and kind of go off the grid, have chosen to change either their location, their email, their phone number. And if they're not really tech savvy and they're using Zoom maybe for the first time, they just uploaded it, they're not aware that your Zoom profile, if you're using a cell phone number, will give away your cell phone number. And instead of my Zoom name underneath saying Marta Estevez, it would disclose my cell phone number. And I actually sat in on a presentation where one of the judges had called in, and I don't think she realized or knew that her phone number was popping up under her name. And so anyone and everyone who would have wanted to write her personal cell phone down probably could have. Additionally, if they've already had something set up and it's going by their email or a nickname or pet name, it might not be the most appropriate nickname or pet name to have as your Zoom. So we tell our participants and our clients, please make sure to be familiar with the profile settings. Make sure that your name appears as it appears in your court pleadings, because depending on whether you're in an open forum on Zoom or if you're in a wait room, the judges will pull based on what the pleadings say. So if your pleading is under Jessica Abel, but your name or moniker on your Zoom profile is like mom of three or proud mom of three, the court's never going to know that. And so we always ask that you replicate the name on your pleadings to the name that you have on your Zoom. And that way it makes it much easier for the court to call you, and it keeps the confidentiality if you're trying to, keep your name, email, or phone number confidential.
Yeah, I think those are all really good points and things that are very easy to overlook. If you have a client that's at all unsure, it's like, I don't know how this works or what name's gonna show, I would say just do a Zoom call with them in advance. Just do a practice Zoom call, say, this is what shows up or this it doesn't. And that's a good way to also test, if they're not the most tech savvy, sometimes that's necessary to make sure their technology is running and they installed it right to begin with. So definitely remember the fact that you can do kind of test phone calls with them ahead of time.
And when you're doing these test phone calls, another thing for you to keep in mind is location. So some of my participants or clients have moved away to an undisclosed location, and perhaps that undisclosed location is really known to the respondent, but he's not or she's not sure that they're really there. So I always tell them, if he's been to your mom's house and you're now staying with your mom, and your mom has a very, colorful couch, don't pick the colorful couch that he sat on with you a million times before. Make sure that it's an area that is as nondescript as possible. Make sure your back is not to a door so that in the event that someone were to walk in, they're not interrupting the Zoom proceedings. And make sure that there's nothing identifiable about the background that you put for your Zoom hearing. So if there's pictures of maybe where you are and the person can actually see them, look at them, and maybe get an idea of where you are, those are all things that could increase the potential for the respondent to find out where you are and to maybe make contact or try and come find you. So location and kind of obscuring your location is really important in these cases, because we don't want to inadvertently give away the safety of our client. We don't want him or her to just show where they are or have someone walk in the background that you can then say, oh, she's staying with her best friend in, Gainesville, or she's staying with, her cousin in Miami. So those are all things that we need to keep in mind and kind of think of how our client's appearance and participation could negatively impact his or her safety.
Yeah, I think those are all really good points. And I mean, the location thing, I don't really have anything to add except to say that that has come up in hearings of mine where the clients have been very concerned about that, they would notice things. So it definitely is something that will come up, or most likely will come up if you deal with any kind of domestic violence victims. That's a real concern.
So we're going to get into some additional safety concerns that I've seen. And one of the issues that I've noticed is because we're in a shelter-in-place, shelter at home, people are not really going out on a daily basis. Some of our domestic violence survivors are still under the same roof as their abusive spouse or partner. We have seen petitions that have not been granted the ex parte temporary, been given order setting hearings. And I'm only going to speak about my opinion. This is just what me, Marta Estevez, believes and thinks. But it is my opinion that these order setting hearings on injunctions for protection against dating, against domestic violence, when the parties are living under the same roof, create a huge potential for safety concerns when it comes to their appearance at a final hearing when both parties are under the same roof. And although a temporary has not been issued, the potential for a final or a temporary to be issued at that hearing based on what the testimony from the petitioner is great. And so now you have a respondent who has been accused of some sort of domestic violence or threat of violence. There was no original temporary in place. They had a hearing. Something happened during that hearing that sparked concern with the court, and the court enters a temporary or a final. Now, who is going to act in the time between the Zoom meeting is left, law enforcement gets the paperwork, and someone goes to serve that respondent and then remove him or her from the premises? And so I really feel that it's important for us to stress, and here in Broward, we have a local form. I don't know if it's available in other jurisdictions, but there is a form on how you wish to proceed. So if you go for your ex parte and it's denied, you can ask the court immediately to just dismiss everything. Never send the paperwork to the respondent. It's as if it never happened. And I think in these times, we should really stress either supplement the petition to see if a temporary is granted and the abusive person is removed from the shared residence, or ask the court to just outright deny everything and dismiss it all, because I do feel that there is a huge potential for some safety issues and for harm to the petitioner if the parties are still residing together, there's no protection, something happens, and then you're left just waiting. You're at the mercy of whoever's going to come to serve this paperwork and hope that nothing bad happens to your client who's under the same roof.
Yeah, I mean, I think there definitely is kind of these additional safety concerns, and that's not what I personally have seen lately, but I mean, I think it's a very good point, and I think that form is a good option. We don't have a form like that, but I made note of it to try to something like that, because I think it is a good point. There's also some, just because of, as has been pointed out, the world we're in right now, and so many procedures are kind of off kilter from what it normally is. There's been some things I've seen where people have kind of delayed in getting that initial temporary injunction because the clerk's office is not operating at its normal operations. Like most of our clerk's offices are closed, and they have like a sign that says call and we'll come up and help you kind of thing, or they're by appointment only. And a lot of our clients start out just by going to the clerk's office and filling out that paperwork. So it's kind of like those options are being more limited than they have been in the past. And there's also been some budget cuts for clerk's offices across the state on top of that during this time. So like I know one of my counties is no longer open on Fridays for the clerk's office. So there's kind of these other factors kind of just impacting kind of even just that initial, just getting that paperwork to begin. There's also I've also seen kind of delay on the opposite end of things, which is that when we have in-person hearings, usually the client or whoever petitioned for the injunction walks out the door with that paper copy in their hands. I always make sure they get it before we leave the courthouse so that they have it immediately. Nowadays, since it's all virtual, they're doing a lot of like, well, we'll email it to you, then you email it to them. And so there can be some delay in them getting that final injunction, which, I mean, the adverse party was on notice and knows about during the hearing, but still, if they were to have to call the police, sometimes the police want to see that paper copy and want to see that final injunction. And if they don't have it in their hands yet, that's something that they need to be aware of. And I've definitely had that conversation with clients too about, I'll get you the final as soon as I can. I will forward it to you via email so you have it on your device, and we'll mail it to you so you have a paper copy, or you have the ability to come to our office. We'll make sure you can pick up a paper copy, to have that, and to make sure to tell the police, like, if something happens, you don't have it yet. This is the temporary, we had the hearing, it exists, and try to, so that they can vocalize what's going on, since it is a different environment than it has been in the past.
And that is definitely something that we down here are seeing as well, is that extensions either after the 15-day return hearing for lack of service, or just extensions to accommodate a longer than 15 or 20-minute trial, which is usually the extent of the time we have at our first return hearing. And final judgments are just not being pushed out as fast as if we were there in person. Everyone signs receipt that they've received a copy in open court, and heaven forbid there's a violation or contact made by the respondent, the petitioner has that piece of paper right in his or her hands right away and can say, there was a violation, we were both served in open court, and pursue that. So the delay of service is really something that's been challenging. And I have forwarded, we get case management notes from our case managers saying that our hearings have been reset for a certain date and time, but it doesn't contain an attachment with the extension. And so we're kind of struggling with that, because like Jessica says, it may get eventually emailed to us, and then we would then have to forward that email to our client, and when we get a hard copy, mail that hard copy down the road. And even the mail is a little bit backed up right now, and so it's not an immediate thing like it was when we were in person, where we were assured that our petitioner was walking out with a piece of paper in hand, that if a violation needed to be brought up, law enforcement could act upon the piece of paper in their hands to know that it was valid and enforceable. So some of the pros and cons thus far that I've seen are that we're saving a ton on travel. Our clients are also, because parking, especially here downtown Fort Lauderdale, it's really expensive. It can run upwards of $20 for a short period of time. And so that's really good that we're not having to add extra expenses to our clients, and that they're not having to either take a couple of buses to get to the courthouse or figure out how they're going to park and pay for it. It's also very convenient that we're doing this from the comfort of our own home. I've been lucky that my 3 dogs have not barked yet today, and that you guys have not been kind of had to listen to that and tormented by it. But it is nice that I'm home and that I'm able to work from the convenience of home. And obviously the overreaching pro is that our health is being protected. We're not coming into close quarters. We're not being around, at least in our courtroom and our courthouse, hundreds of people cramming into an elevator in the early mornings to get to motion calendar or the early morning hearings. So those all, I think, are wonderful. And I think that it's a great positive step for these Zoom hearings. Jessica, have you seen any others that maybe I forgot?
I mean, I think for some victims, it's a big benefit to not be in the same room as their abuser. They still have to see them via camera and stuff, but to know that they don't have to be in the room, even though it's a safe environment with bailiffs and everything like that. I've definitely had some clients tell me, well, I'm glad at least I'm not sitting in front of them in person. Like, this wasn't stressful enough. I can't imagine if I was in the room. So it does give a little bit of some distance for some people that I think is useful.
Some of the cons that I've seen and that I find impact our clients and those we serve is that the Zoom hearings can be a little bit intrusive. And by that, I mean that if I have been forced out of my home that I shared with my abusive partner. And perhaps I'm either staying with family or friends. I've even maybe gone to shelter or a hotel room. The fact that my camera is on and that my abusive partner gets kind of like an inside view of where I'm living, to some petitioners, to some victims, could be humiliating. It can be demeaning to them. Perhaps they're not in the same living life, they're not in the same lifestyle that they were accustomed to or that the respondent held them to. And so it's kind of a glimpse into their life that they may not want to share with an abuser. I also have read, going back and forth in preparation for this, that some judges, especially in family court and dependency court, are using this as kind of a mirror into your home to assess, whether or not they feel, and I'm not sure how they can make this prediction, but whether or not they feel that your home is adequate, whether or not it's, it's the best interest of the children to be in that home more than in the other parent's home. And so for some, I think that this could be really intrusive. And so I think that that is definitely one of the cons of having a window into my home and into my life, as opposed to being in a physical courtroom. I also think that when we're in person, there is much more control of the courtroom. The bailiffs and the court has a little bit more of a commanding presence. When we're at home, it's a lot easier to interrupt someone else. It's a lot easier to cut somebody off. And the fact that Zoom will pick up small noises and kind of cut off a person to let the other person's speaker come through is just part of that evidence that there's better control when you're in person. The judge can reprimand a lot better when you're in person. It's a lot more authoritative from the bench when you're there in person. And for anyone who wishes to get unruly, then the courthouse bailiffs and our armed staff at our courtroom could definitely take control over that. And then as an added problem is the safety, is, participants doing it at home or in a public area, and what safety precautions are being taken. We know at our courthouse, especially, we have a really wonderful relationship with the sheriff's office that handles the courthouse. And so our petitioners can be walked to and from with escorts if they feel that they're intimidated or afraid. We have separate waiting areas for the respondents, and we kind of have that extra eye on them. We also have the use of metal detectors for anyone that's coming and going from the courthouse. So those are things that, even though everyone's in their own home, we don't have that extra layer of protection for victims who are appearing on these Zoom hearings at home or, by themselves.
Yeah, and I think kind of a big in addition to the cons that we talked about kind of before about access to technology and stuff and that sort of challenge, the biggest one, kind of courtroom control, has definitely been an issue for me. And if you have clients if you have a client that tends to be willing to talk more and interrupt, and regardless of whether it's a hearing and they're going to say their piece, it's hard when you're not sitting next to them to go, no, wait, you'll get a chance, I promise, please wait. It's hard when they're via camera. You don't want to say that. So if you have a client that you think that would be an issue, I definitely think that if you can be with them in the same room at your office safely, it's a good option to have. And it's definitely one I've used for ones that I'm like, oh, we need to be together during this hearing. And make sure they know even where the mute buttons are on things and stuff. That if they want to mute, obviously they can't mute themselves during their testimony, but if the other side's talking and they're going to be sighing heavily, throw the mute button on. The microphone will pick up more than you can judge in person. So that is definitely something to keep in mind, and kind of just judge by what, I guess, the circumstances you're in and who your client is and their personality and what's going to be an issue. Because I would say also on the opposite end of that, I think I've had some that probably are less vocal than I would like and kind of more afraid to testify, because if they're sitting in a courtroom where they feel more empowered in a certain way when there's bailiffs there and I'm sitting there next to them, that can help some people testify and speak more, versus when they're at home and they kind of feel more alone, for lack of a better word. So the opposite problem is also a real issue. So I would say really kind of judge the personalities involved and make your best guesses and make your best efforts to deal with those problems.
We did have a question come in. First to comment, someone said the in-person has been more effective for them as a DV advocate. So we can maybe discuss that a little bit more later, especially in the breakout rooms. And then the question from Martha is, how is the participation of witnesses handled?
We are going to get into the participation of witnesses and how to take witness testimony and how to present the evidence further down in this, but we have treated it just like any other witness using Zoom. So kind of just the same way that you prep your client for the Zoom hearing with the same, you know, privacy considerations, labeling your Zoom link, and we'll talk about it in a minute. I've had really good success with law enforcement officers participating as witnesses on Zooms. I've had a couple of city employees. I've actually asked my victim advocates from our local law enforcement-based departments to come and participate because they do have a right to be with a victim through all of the stages. And so there is the right to have a victim advocate present. And so I've asked the courts to allow them in. So we will get into that in 1 second, I think. So real quick, hopefully thus far in this presentation, you've learned or at least started to think about how limited access to technology, limited income could equal a really negative impact on meaningful participation by your client, by your petitioner in domestic violence hearings and any other hearing which is being done by Zoom. So I put up a couple of things here just for us to have. The infographic on the right, I can't take credit for it because one of my colleagues and my partner at the office made this for me. It's just tips. I'll freely share it with Christy and then she can give it to the group if you're interested, but it tells you what happens if you don't have, you know, access or don't know how to access things. We have two different types of Zoom hearings. We either have a waiting room, which is what some of you might have experienced when you joined. You were put in a wait room. You just get a white screen. It should tell you the circuit you're in. Ours just say, you know, waiting for Judge so-and-so's docket to begin. Sometimes their case manager will chat on the side, letting you know, thank you for your patience. This Zoom will, you know, start shortly. And then other judges tend to use an open room. I've seen that a lot more when I'm doing motion calendar, not so much in DV full hearings, but some judges have an open room where it's kind of like the forum we have now. The judge sits up on the bench and just calls names and asks people to, you know, go when they're ready to go. So depending on what you have, you always have the option of asking the court if they're going to be able to use a breakout room. So like Jessica was saying, if there is that moment where your client may be coming a little bit unglued and you need to just bring them back, you can ask the court if they can put you in a breakout room so that you can privately talk to your client and just kind of let them compose themselves, get things squared away, and then resume your hearing if necessary. We have our judicial directory and list. Tells all the judges their Zoom link is hyperlinked in there, as well as their division procedures. So you can cut and paste any of the links. I forward them to my client just in case. It's easier for them to click the hyperlink than it is for them to type in the Zoom links which appear on their temporaries. And I have a screenshot of that for you guys. So like I said, the information should be on the temporary, and I'll go. So this is one of my temporaries. As you see, it tells you the division, the judge's name, and then it'll give you each Zoom link for that judge. It also gives you various numbers to call in the event that you have an issue with accessibility and cannot get on the Zoom calls. And then it tells them that, you know, this judge asks people to log in at least 10 minutes before their scheduled hearing time. So those are all standard in our forms here. And they created, as well as the Zoom links and all of that, we in Broward have a case manager email where you can send questions as a pro se litigant, or if you're unable to join, to case manager inquiry at 17th.fl courts. So we have that email available to not just ourselves, but our clients, that if there is an issue with them joining or they can't get their audio connected, they can communicate with court staff through that case manager inquiry email. Yeah,
and in our area, we have, it would just be too easy for them to all do the same thing. So we have 7 different judges that does 7 different things. We have a couple judges that are actually using Teams, Microsoft Teams instead of Zoom. because they all started off using that because they didn't want to pay for Zoom. And then when this kept going, the courthouse broke down and paid for Zoom. And there was a couple judges who were like, I just learned one thing. I'm not learning something new. I'm going to keep on with Teams. So we have a couple judges that have a different system. And then our links are either in our notice of hearings. Some judges want them in the notice of hearings and or with a temporary injunction. I don't think they have it as part of the form. I think they have a separate handout, but given at that time. And then we have other ones that just email out the link, 15 minutes before the hearing. It says we're going to send the link, we're going to email it, and either forward it to your client, or the JA will ask for our client's email address to send it to them as well. So yeah, so it is very, very area dependent, I would say, but definitely getting that information sooner rather than later is definitely preferred, and knowing what your judge does and what they like, and installing Zoom or Teams, or I'm sure somewhere in the state somebody's doing some third option. So yeah, definitely make sure they have the right technology installed and are aware of how to use the right option is always good.
All right, so now we're going to get into the presentation of evidence, both testimony and physical evidence. And Christy, if the person that had the question has a follow-up question, if we don't answer what was being asked, please chime in and let us know so that we can try and answer their question. So for witnesses, make sure you invoke the rule. And normally our judges give us, when they call in the case, they give us a couple of seconds to briefly describe what's going on or what needs to happen in that particular hearing. If I know that there's witnesses, I will tell the judge, Your Honor, I have, Fort Lauderdale police officer so-and-so, I've got victim advocate so-and-so, I have, the city of Pompano Beach surveyor named so-and-so, all in the wait room. They're all witnesses for this case. Sometimes the judge will bring them all in quickly, give them a brief rundown of what's going to happen, and let them know that they're going back in the wait room, and it's not because they're not taking the case, but rather they cannot be present while the testimony of the participants or the litigants is being heard. If you are participating in Zoom and you see a name or a number that you don't recognize, please know that you should invoke the rule, make sure that it is either court staff or personnel, but not someone that is a party or a witness, because then you've just damaged your case. Make sure you ask, when you have a witness on the stand, who's around them, who can hear them, what device are they using, are they communicating with, say, the respondent or the petitioner, are they using their cell phone to text or message, and keep your eyes open for anything that you see out of the usual or norm for your witness. So if your witness is constantly looking down, or you can obviously tell that they're communicating with someone, bring it to the court's attention. Make your record very clear, because one of the things we'll talk at the very end is how these Zoom hearings are affecting us emotionally, and how we're not picking up on certain social cues, and it's causing fatigue. And that's one of the things, because we're just seeing very limited parts of the litigants. We're basing credibility on, these large heads that float in boxes and light up with yellow. And so we're not really getting a real sense of the demeanor of the witnesses. And so I think it's completely okay for you to ask witnesses on the stand, who's in the room? Is there anyone there? Can anyone hear you? Are you married? Is your spouse there? Is anyone related to the petitioner or the respondent in the vicinity that could be giving you, information or feeding you answers to the questions that I'm going to be presenting? Is anyone standing off camera or behind the camera? Because we do have that link that I showed you with the judicial directory that has all the Zoom links, I include that Zoom link in all of my subpoenas that I send out. So I said the hearing will be held on such and such a date, and if still remote, will be heard by Zoom, and I put the hyperlink in there so that when it is served upon the witness, they will have access to the Zoom link for that particular hearing. Jessica?
I mean, I really don't have much to add because I think you've covered just about everything for there. But I guess the one thing I would say is just keep in mind that basically everything we talked about earlier on about issues with our own clients can also be an issue of witnesses, as far as their location, their technology options, especially if it is like a family member or a friend of the victim, that they may not, if it's an officer or, another professional, they hopefully have had options and know how to do that. But if it's just somebody else, they're going to face the same issues that the clients face as far as technology options and Wi-Fi and all of that. So just make sure to have those conversations in advance.
So in terms of physical evidence, we have an administrative order signed by our chief judge in May 26th of this year that says that no later than 2 business days prior to a hearing, we're supposed to upload this information to the case management system as pre-marked exhibits. And one of the things that I've noticed is it's not that big a deal for myself or any practitioner because we're familiar with uploading proposed orders, final judgments, and things into the case management system. But this administrative order also goes to pro se litigants. And so I'll talk a little bit about that in a second, but it adds an extra layer of complexity if you're a pro se litigant with limited means that you're not going to have to learn or see how to navigate the use of a case management system. You're going to have to create a username, a profile, an email. You're going to have to know how to upload it. And although some people may be able to participate in Zoom hearings, get their email off their phone, not everyone has access to a scanner. A lot of our clients try and use their phone camera as a scanner. And so all of those things are really going to impact the ability of a pro se litigant trying to introduce evidence into a hearing. We have had some clients who want to show you their phone, and unfortunately that doesn't really always work. The quality is not good. There's a glare. The judge is like, move left, move right, bring it up a little, bring it down a little. And so it really takes away from the importance of the evidence that you're trying to present. It also needs to be said that go over these exhibits with your client so that when you say, I'm going to show you what has been marked as petitioner's proposed exhibit 1 for identification purposes only, that your client knows what you're talking about and not what, you know, which one is that? Is that the one I sent you, or is that the one of the car? So just make sure that I usually send them all the proposed exhibits when I file them into case management. I send them to the client as well. And I say, look over them, look at the numbers I've assigned them. This is what I hope to be the order in which I'm going to call these. You know, and I'm going to ask you certain questions based on each one, but I'd like you to become familiar with them. And then for my own purposes, I make a folder, you know, with the client's name and exhibits so that depending on whether the judge in that particular division allows me control of the screen or if the judge controls the screen, it's all going to be dependent. But if I'm controlling the screen, as soon as I do share screen, I know where that folder is with those pictures and I don't have to thumb through or try and look through my directory to find these photos. Some of our judges are really, really hesitant to allow you access to their screen share. I'm not sure why. So they kind of fumble through it until they share it with you, which, you know, it's fine. The other thing is that our administrative order says once we have the hearing, once they're pre-marked, once they're entered, then the clerk has to do an evidence and an exhibit list, and then we have to follow up and submit what has been entered so that there's now an accurate record of the evidence that's been presented. Our case management system does not accept all types of files and all types of uploads. So there are certain things that you may have to make an appointment with the clerk to then drop off either your USB or your CD or whatever it is that you wish to upload, that the format is just not supported by our case management system. So it's kind of an extra step that you have to take. And as practitioners, we kind of are familiar with going to the courthouse, with checking in with the clerk, giving them our information, our documents. But for pro se litigants or self-represented litigants, I really feel that this puts them so behind in their ability to participate and to really have a meaningful trial with the full presentation of evidence, witnesses, and everything else, because there are so many nuances that just aren't common, and that it's a learning curve for us who have been at it for a long time, much less for someone who is just now trying to come up to speed on how to file their own documents and kind of work the system.
Yeah, and in the third, we don't have any administrative orders, so it is just kind of play it by ear. If you're in an area where you don't have that option, I would definitely reach out to the judge's JA to ask how that judge prefers if you don't know that answer, because I've had different answers from different judges and they very much varied. Most of our judges have allowed the screen sharing, and that's been that's been something I've relied on quite a bit, because if the other side, especially if they are pro se and I don't have any way to email them exhibits or anything in advance, that's kind of my main way to make sure they can see what's going on and what I'm sharing and talking about. If there's counsel on the other side, then usually we just emailed them in advance to each other and it's been exchanged that way. But yeah, if the other side's pro se, it definitely does some additional challenges. The screen share has been my best way to get around that, but of course that's judge dependent on whether they will allow it or not. Yeah.
And kind of adding another layer of complications to what we've already discussed is kind of complicated for petitioners is the use of Zoom with your limited English proficient clients. And it's because traditionally interpretation services, which are by statute given to petitioners in these hearings, is simultaneous. But unfortunately, Zoom does not allow for simultaneous interpretation, and so they have to rely and fall back on consecutive. The problem with consecutive is there is a big pause between what was said by the petitioner in his or her native language, whatever the court interpreter was able to gather, and then what the court interpreter then relays back to the court. And so I am bilingual, I speak English and Spanish, and for me, it has not been as big of an issue, because if there is an issue, if there is a misinterpretation or something that gets lost in translation, I can very easily ask the court or the court interpreter to kind of rephrase it or say it again, and I can tell the court why I'm asking for that. But there has been a big problem. We recently, one of my family law attorneys told me that they did this by having the interpreter call the victim on the phone. The victim muted herself, and then the interpreter was the only one speaking. So it kind of took that second party out of the Zoom audio, and so it was able to flow a little bit better. And that might be something looking in the future. I did reach out to our court interpreters before this hearing today, before this meeting today, and they are working on trying to figure out how they can do simultaneous, especially as we look forward to opening more and more parts of the courthouse where translation and interpretation services are so integral to, first appearance court and jury trials, that we really need to get this under control and mastered before we open up the case, the cases for other types of cases and potentially create bigger problems with interpretation or misinterpretation.
Yeah, I have not had to deal with this yet myself, but I know I've had more than one colleague who has had to have this issue, and it definitely adds, like you said, just another layer of complications. I know one of my colleagues I don't think their hearing has happened yet. I think it's still upcoming, but they've arranged and gotten all sides to agree to the interpreter is going to come to our office and be in our office in person with the client who's also going to come in person to allow that simultaneous kind of interpretation, because it's already set for an all-day trial. And if it was to be consecutive, it was just, realistically, it's not going to get done in a day. So that's kind of the workaround we figured out from this particular issue, this particular one. But it is, going to continue to be an issue, I'm sure.
We discussed wardrobe and wardrobe malfunctions. I pulled up just two of the first ones that I saw, both of them out of Broward County. Unfortunately, we just have not had the best of luck with attorneys and litigants having proper courtroom decorum. So our chief judge came out to denounce that not wearing pants is a no-no in Zoom. Public displays of affection between you and your spouse while you're in a Zoom hearing or waiting for Zoom to be called is a no-no. And so they're really starting to clamp down on what is appropriate, but it leaves us with the information that we need to talk to our clients about what is appropriate and what is inappropriate when it comes to their appearance on Zoom. And that goes back to what we said initially about access to their cameras and their devices. Do a practice run. Let your client know if she or he is too close to the camera, too far from the camera, if the camera is not in an angle that is appropriate, and let them know that it's not, even though we're not in a physical courtroom, we still need to keep the proper decorum and we still need to act as if this were in person. And so their dress is very important, and nothing too low cut, nothing revealing, obviously nothing with you know, any kind of vulgar, you know, language or inappropriate messaging. We had another one of our judges said that he saw one lawyer shirtless in a Zoom hearing, a female one in bed under covers, and then another one lounging by the pool. So this has been a recurring theme. I think we're getting a little bit better, but just it's part of the reason why Zoom kind of desensitizes us. We're very quick and very used to standing behind the laptop and chatting with friends and family. But this is employment, this is our jobs, this is the courtroom. And so we have to make sure that we keep the professionalism that are, you know, that as lawyers we are expected to have.
Yeah, and I think that's important for us and for the clients to remember as well. You know, it is, even if they are dressed appropriately and everything, it is very easy for them to kind of forget the formal nature of court when they are sitting on their couch in their living room. One of my judges is ex-Marines, and so he very much likes everything to be a certain way, and you sit up straight and all that. And he has expressed on more than one occasion, not to my clients, but just specifically, but just in general, how he hates this and he feels that nobody's respecting the court. So there are some judges that are having a really tough time with the transition and really reminding the clients to be extra on their best behavior, and that, you know, sitting up straight and, you know, that sort of thing. Even though you're at your house, it is still a court hearing, and there's rules and appropriate decorum to follow.
So this slide just shows Texas held a jury trial by video conferencing, and we were going to try and put the video in, but it just got, first of all, we're running short on time, and second, it just got a little bit complicated to share the audio and the video. So one of the things that was interesting on this is that they had two judges presiding in the trial, and one of the articles I read said that one of the jurors took a call in the middle of some testimony. So there's some added issues with having these jury trials. We'll see how they play out, but you know, it looks like Texas is starting to do their trials by jury, their jury trials by video conferencing. And then probably what you guys are all experiencing right now is Zoom fatigue. You're probably tired of Jessica and I by this point into the hour, but is it a myth or is it reality? And there are plenty of articles out there that say that Zoom fatigue is a reality. One of the reasons is because we get so much extra stimulus from Zoom that we don't necessarily have when we're in a one-on-one meeting or an intimate meeting with either colleagues or clients. We get the visual cues from people's living rooms. If they have a dog or a cat or a significant other that walks into the room, we're seeing all these things, we're hearing all these noises. So all of that is really playing into the stimulus that we're receiving. And so it is a lot more draining on the recipient of that information. It's taking a bigger emotional toll on us. One of the articles said that, you know, we're really trying to be engaged during our Zoom hearings. And so because we can't pick up and feed on the visual cues, I'm not seeing anyone's face during this, I'm just seeing your names. So it's really hard to feed off of the visual cues that we would normally get to see whether or not we've exhausted the topic and we should have moved on to something else, whether we're hitting points that are either exciting to the audience or boring. And so these are some of the things that when we're in a group together, we can feed off of, we can hear, we can play off the group. We're not getting that. We're not getting the nonverbal cues that are hidden in video. We don't see if someone is, you know, agitated or, you know, dozing off. And then some of us have, you know, like I said at the beginning, some of us have an anxiety that we're going to get interrupted. I'm shocked and amazed that, you know, Amazon hasn't knocked on my door and the dogs have gone wild, or that someone hasn't walked in, you know, my significant other is home, if, you know, hasn't walked in to check and see what I'm doing, you know, at 3 o'clock in the afternoon. And so we do have that kind of anxiety. What is the other person on Zoom going to see in this meeting? Are they going to be able to see a little glimpse into my life? And maybe, you know, it's embarrassing to me, or, you know, if you have a child that likes to run around without pants, you know, are those things that are just going to pop up in your staff meeting or during one of your hearings with the court? And so they are talking about these Zoom fatigue syndromes. and how people are really burning out. One of the things that was suggested is if it can be done by email and not a Zoom meeting, then do it by email. If it can be done by a phone call with just you and another person, do it that way, because we really are kind of taking an emotional toll on ourselves. And we're all in this for the mission. We're all trying to help as many people as possible. We're juggling the new norm. We're juggling staying at home, the fears of quarantine. And so we really don't need to add more stress to ourselves as practitioners. So imparting, my last thing is going to be take care of your clients, but take care of yourself too. Make sure that you are focusing on your own health and your own happiness too. Hopefully this has been an informative chat. Like I said, Jessica and I will stick around for the breakout rooms. We'll talk to anyone who wants, and if Christy has questions, we're going to answer them.
Don't have questions. I've gotten compliments, but thank you both so much. That was such good information. I always learn a lot when I talk to you too, and I just have such admiration for the hard work you do every day. I'm finding it hard to believe all the things you have to take into account on a regular basis and now during the pandemic. I did want to let everyone know, I forgot to announce at the beginning that the public interest law section of the Florida Bar has been wonderful about co-sponsoring all of these Tech Tuesdays, which keep on expanding because people have such great ideas for them. So I really appreciate that and encourage anyone to join PILS who is not already a member. And on that note, Cabral Banner at the Florida Bar has come through with the CLE just in time during this webinar. So the CLE number is 4160. Again, that's 4160. And I did put it in the chat box also. It's approved for one general credit and one technology credit. So thank you so much, Cabral and Pills, for helping out with this webinar series. And we're going to go ahead and take a 5-minute break. So we'll be back at 3:07 for anyone who wants to join the breakout room. So I'll give everyone time to move around a little bit, unfatigue yourselves from Zoom fatigue, and come back for breakout rooms so we can all get together. Thank you all for joining, and thank you so much, Marta and Jessica. I really appreciate it. See anyone?
Thank you for having us, Christy.
So I'll see anyone
Thank
by 3:07 who wants to do the breakout rooms. And I will stop the recording now so we can speak freely during breakout rooms. See you in 5.